One of the most recent developments in the 340B program is that we have a new administrative dispute resolution process that has come out in guidance this year.
So historically, the ADR was put into place through the Affordable Care Act back in 2010. But unfortunately, it was delayed and no rules were put in place until 2021. When those rules were put in place, there were several lawsuits that ended up stopping them, and new rules have just released in this past summer.
So some of the positive things that are associated with the new administrative dispute resolution process that has come out is that in contrast to the one that was originally released, there has been a shift. So the first one was very almost litigious in the way that it was designed. So they used a very formal construct and looked at more processes that would be more like being in a actual court system. And the administrative dispute resolution process that was published this year in 2024 has looked at making sure that it's accessible to covered entities of all size. So whether you're a small federally qualified health center or family planning organization or a large hospital system, it should be accessible to everybody.
Another change they made was that they were limiting the panel to 340B subject matter experts at HRSA and the Office of Pharmacy Affairs. This is important because you're going to be getting experts that understand the program and understand how it's operated, and you don't have external people that are going to pull in other factors other than the rules governing 340B.
The previous panel in the ADR process that was described before actually had members from many areas across the federal government who did not necessarily have expertise in the 340B program, which would make it very difficult for them to hear the cases that were being brought by the covered entities and the manufacturers and make decisions that would be appropriate. Another new change within the administrative dispute resolution process is that elements that are being heard in the courts can still be heard by the ADR review board. Why is this important? We actually had a number of cases or complaints that were brought before the first ADR panel, and they were dismissed because similar cases were being heard in the federal court system. The challenge with that is that covered entities, as was decided by the Supreme Court in Astra versus Santa Clara, do not have an opportunity to seek a court case within the traditional court system. Our pathway to having a dispute is through the administrative dispute resolution process or the ADR board. So when we aren't able to put a petition before the ADR board because a manufacturer is challenging HRSA in the federal court system, that makes it very difficult for covered entities to bring any grievances forward. Now, even if a similar court case is happening in another system, we are able to bring that forward. The other piece of that is it can take years to upwards of a decade for things to make it all the way through the system, and we may have covered entities who are sitting with grievances that can't be heard. So the new process has been designed to be more accessible, and another interesting piece is the timeline that the Office of Pharmacy Affairs has put in as well. Do you want to talk a little bit about that?
As Felicity said, when we're going through litigation, we have a long timeline. It could sometimes be several years before you actually get a response. The great thing about the new ADR process is that HRSA has assured covered entities that they will have a response within 1 year, which is great for smaller entities that don't have a lot of revenue to be able to upfront a long legal battle.
So once covered entities have actually put in all of the information for the filing and HRSA receives everything from the manufacturer's side, they take a year at most to consider and get that ruling back as far as the panel to the covered entities. So now this is a great point for us to pause and talk through what does that actual process look like. So before before you even begin an administrative dispute, the expectation set in the guidance is that manufacturers and covered entities work together in good faith to resolve any issues. And at minimum, this should be a month. And so covered entities should reach out to the manufacturer where they are having an issue and alert them to the challenge that they are facing, whether they're not able to access pricing, not able to receive medications, 340B medications within their covered entity or their contract pharmacies if they believe that they are eligible to do so, and attempt to work with the manufacturer. Not always is that something that can be resolved. And if the process of good faith does not work out, that is where the covered entity has the opportunity to submit data to the Administrative Dispute Resolution Panel for consideration. So not every submission is going to be taken up by the panel. So they will consider what is being put forth to determine if it meets the required elements. Once they decide if it qualifies for review, they will alert the party that is involved, so the manufacturer. An interesting thing is that covered entities can file jointly, whether it is multiple covered entities or filing through an association to be able to group, but they are only able to submit claims with a filing for one manufacturer at a time. So it can be one covered entity with one manufacturer or multiple covered entities with a single manufacturer. The same happens vice versa with the manufacturers, or it could be one manufacturer with an ADR filing for a single covered entity, or multiple manufacturers with a single filing for one covered entity. But we can't have a mix of the different groups based on the filings. So the next piece is, once the parties have been alerted, everybody has an opportunity to submit the information from both of their sides to the Administrative Dispute Resolution Board, and they will consider that information. Within that 1 year time frame, you can expect to get a decision back. That decision has an opportunity to be challenged by either party. But once a challenge is issued, it will be reviewed by the secretary, and then that decision, that either the initial decision, if not challenged by either party, or the challenge decision that is then submitted secondary to the challenge, will be considered binding. And that is how the administrative dispute resolution process works. Sounds simple in theory. The Office of Pharmacy Affairs is still publishing some additional guidance and requests for comments on how it will flow as far as some of the operational elements. And any of the covered entities or manufacturers who have filings from the previous process, they will have an opportunity to move into the new process once it starts up.
Another factor with the new process is that it clarified that manufacturers can bring issues for managed care Medicaid duplicate discount concerns. So something covered entities should be aware of is that there's likely going to be an increased scrutiny of managed care duplicate discounts inside of the space. We might see additional manufacturer audits being requested from HRSA, so that may lead into this whole process.
Part of the requirements for the manufacturers before they enter administrative dispute resolution is the conducting of an audit to make sure that they would have valid grounds as well. So it's going to be an interesting time as the new Administrative Dispute Resolution Board is launched. We do see it as a positive development, again, because they've made the process so much more accessible for covered entities. But we do see that there will be challenges even in the more accessible process, especially considering all of the different areas where covered entities are being restricted from accessing the program today.
For any covered entities that are thinking about going through this process, it's important that you talk to experts in the space to really decide how best to proceed. That may be working with your primary care association, the National Association of Community Health Centers, or even legal counsel to make sure that you have a sound filing and that you can progress through the process in a great manner and be able to get through the process and be successful in your goal.
Yeah, and before anybody moves forward with considering an administrative dispute resolution process, it is imperative that you do attempt to work with manufacturers in good faith first.